Welcome. This is the Legal Broadcast Network, and this particular broadcast is a service of ATG Trust. My guest is the tax lawyer, Rob Wood, partner at Wood & Porter in San Francisco, and his article in Tax Notes, the top 10 tax mistakes made by contingent fee lawyers. Please welcome Robert W. Wood. Hi, Rob.
Hi, Scott. You're sounding very formal today.
Well, I feel formal. And I'll stop doing that if that bothers you.
No, it's nice.
Talking about contingent fee lawyers, in one sense, they're always pretty good at what they do. They try to shy away from the tax implications, or sometimes they do it unintentionally, probably because they don't feel too confident about that area. But then again, that's why we have you.
I guess that's right. And of course, any time that you point out mistakes anybody makes, and especially, I guess, mistakes by contingent fee lawyers, there's a risk of becoming unpopular. But I mean, you're quite right. Contingent fee lawyers have a lot on their plate, and their job is to get the recovery for the client, not to handle tax issues. But I try to point out sort of red flags, things that contingent fee lawyers should think about, so that they can address taxes when the time comes and get somebody involved.
All right, well, let's talk about the first two. Don't overlook the bottom line and don't fail to consider interest, Rob.
Right. Well, and the bottom line one is, I guess, painfully obvious. But if the recovery is, X dollars, doesn't matter whether it's $100,000, $1 million, or $10 million, whatever it is, the client will be thinking about the gross recovery and the net recovery, and the lawyer will too. The net recovery being a subtraction of costs of the case and the subtraction of the legal fees. But of course, that net number, and let's say it's $50,000 or $500,000 or $5 million, whatever the number is, that's merely the cash number, the net cash number, not the after-tax number. And I think it's fairly easy to run the calculations. Any accountant or tax lawyer can do it. In fact, probably many contingent fee lawyers could do it themselves if they wanted to. But computing, and many clients can do it, computing how much after-tax is really important in any kind of a case, whether it's a PI case, employment case, or intellectual property, business dispute, doesn't really matter, but doing an after-tax calculation is a good idea.
Mm-hmm. And when we're talking about interest, explain that a little bit.
Sure, and I actually can combine this with one of the other points, which is punitive damages. I think interest and punitive damages are two things that in the tax field are kind of ever present. They're always taxable, and I think many contingent fee lawyers in the PI area that do exclusively, let's say, auto accident or other kind of personal injury cases, and they're used to thinking quite appropriately that most of their recoveries for clients are tax-free. Physical injury recoveries after an auto accident obviously are tax-free. But the question is, how far does that tax-free treatment go? Interest and punitives are always taxable. So if there's a $1 million recovery for a serious auto accident case, someone who's very seriously injured, and the case has been bumping around the courts and is on appeal, there's maybe pre-judgment and or post-judgment interest, and there may even be punitives. Those latter two elements are going to be taxable. So in those kinds of cases, again, the tax character doesn't go away. There are sometimes ways of planning around it, but that's probably not something that a plaintiff's lawyer wants to do. So interest and punitives need to be considered.
And then we go to an area that we've covered a few times before, and that's kind of the muddy area of attorney's fees, which, again, the settlement agreement is paramount here. But we've talked about the issue where someone gets an award, 40% of it goes to attorney's fees. The IRS will look at that oftentimes as your entire tax liability. And that's something that has to be addressed early on.
Yeah, that's right. And I mean, there's a lot of injustice here, and you know, we don't, tax lawyers don't make the rules, we just live by them. I guess that's true with all taxpayers. I mean, there's been a lot of press about, you know, whether it, about it being unfair that you get, as a plaintiff, taxed on your lawyer's fees, even though the lawyer also is taxed on them. And of course, Scott, as you say, we've covered numerous times, in the employment area, there's now an above-the-line deduction, meaning a kind of an off-the-top, if you will, so that there is no tax paid by an employment law plaintiff on the legal fees. But in many other areas that's not true. So again, back to the interest and punitive damage issue, even in a strictly PI case, if there are interest and punitive damages paid, then some of the legal fees would be allocated to those taxable claims, generally pro rata, and there is a deductibility problem. So once again, these things, if you're doing some kind of a rough tax computation, these issues will pop up, and then you can get some help from the outside.
Mm-hmm. And as we move along here, we still have time. Let's talk about my favorite area, Section 104, and then also constructive receipt, which is again important when it comes to timing and when you take payment.
Sure, and let's do the constructive receipt first. I think that is one that everyone knows something about, but few people, I think, know a lot about. Constructive receipt is this notion that sometimes you're taxable on something even though you don't have it in your hand. The classic example that's usually used is the year-end bonus, where the employer says, Scott, I'm giving you a bonus, and you know, for your work this year, good work, and you quickly say, well, no, please don't pay me now, pay me in January. And a lot of this stuff in real life happens, and I think some of it probably slips through the cracks, doesn't get reported, doesn't get caught by the IRS. But the analytical answer to the facts I just gave you is very clear, which is, Scott, even though you said I don't want it this year, don't pay me, you're taxed on it in this year, 2011, not in 2012. And in the lawsuit area, it's even more clear that you can be constructively taxed on something by having it, for example, in a lawyer trust account. And in fact, this is an area where constructive receipt and actual receipt can get confused. But just to be clear, if money is paid into the lawyer's trust account, the lawyer is the agent for the client. So even though the client may not have receipt of the cash, the client is treated for tax purposes as having received it. This gets confused frequently, but I would just say, if a settlement is happening, settlement documents are in the process of being signed, be very careful if you are a plaintiff's lawyer and you or your client want a structure. Don't sign the documents until you speak to structure professionals and or a tax lawyer. So, I mean, on the Section 104 area, everybody, once again, knows a little bit about that. This is the one section of the tax code that excludes personal physical injury damages. As I think LBN listeners know, there's a lot of confusion about how far it goes. You know, is sickness? What about ulcers? What about fondling or sexual harassment type touching? You know, is that enough, even if it doesn't produce bruises or broken bones? Many people don't. I mean, there aren't good answers to these questions. But I'd say, maybe overstatement, I say, don't assume it doesn't apply and don't assume it does apply. Look at your specific facts and get some outside help if you, as the plaintiff's lawyer or your client, are going to be relying on the Section 104 exclusion.
All right, and then as we can continue here, let's go ahead and wrap up. Let's take the last three together. It's kind of hard because they're all different, but one interesting part of employment law is when part of the recovery is in wages, and that tends to be looked upon unfavorably. But as you point out in the article, yes, they are taxed, but there is a benefit here.
Yeah, that's right, and I think it's funnily enough, I have this conversation very frequently with clients and with plaintiffs' lawyers in employment cases. From a defense perspective, defendants should worry, most do, and they should worry about the big liability, tax liability to a defendant in an employment case is failure to withhold. You know, all the talk about should they or shouldn't they issue a Form 1099 or exactly what settlement language goes in a release, that stuff pales in comparison to failure to withhold liability. So they should want it, and most do, insist that something be allocated. And I think, ironically, plaintiffs and plaintiffs' lawyers oftentimes sort of jump the wrong way on this issue, and they say, oh no, we don't want any wages. They're actually better off, in my opinion, in most cases, if they agree to some reasonable number. Obviously, there's sort of a quantitative question here of how much is enough, and there's no bright line. It's all fact-based. But there is frequently, I'd say most frequently, the IRS does not come along and disturb the numbers if they look reasonable. So allocate something to wages in most, if not every, employment case. Have some amount and treat it as wages, meaning there is withholding. And then the rest of it, as LBN listeners know, it can be structured if you want. I mean, there are commonly structures done now with employment recoveries, but not on the wage portion. You need to come up with something for wages.
All right, well, everybody, for the rest of the information, you can find this article at woodporter.com. Also in tax notes, it's top 10 tax mistakes made by contingent fee lawyers. Do they really make mistakes? Rob, I appreciate your time.
Thanks, Scott.
And you're watching the Legal Broadcast Network.